Think about that for a second. Being struck by lightning. Back in the early 1970s, that's what the American death penalty felt like. It wasn't necessarily about who committed the absolute worst crimes. It was more about who was unlucky. The system was basically a lottery, what one justice called a capriciously selected random handful. It was, without a doubt, a system in crisis.
So how did we get from that chaotic lottery to the system we have today? Well, we're going to unpack this incredible constitutional puzzle. We're about to take a 50-year journey through a legal battle where the Supreme Court has wrestled with one of the toughest questions there is. How can the ultimate punishment ever be applied fairly?
Here's our roadmap for this explainer. We'll start at the moment the entire system got struck down. Then, we'll see how it was rebuilt from the ground up. We'll explore the lines the court drew on who's even eligible, look at the safeguards meant to ensure a fair sentence, and finally, get into the fascinating idea of how the very definition of cruel and unusual keeps changing.
All right, let's dive right in. We're starting in 1972 with a single Supreme Court decision that brought capital punishment in the United States to a dead stop. Now, the key thing to understand about Furman versus Georgia is this. The court didn't say the death penalty itself was unconstitutional. The problem was the system. States were giving judges and juries what they called uncontrolled discretion, basically no clear rules for deciding between life and death. It was that randomness, that lightning strike quality, that violated the Eighth Amendment.
And the impact of Furman? It was immediate and absolute. It wiped out every single death penalty law in the country. For 4 straight years, not one person was executed in the United States. The nation was essentially forced into a constitutional timeout. So this shutdown forced states to go back to the drawing board. They had to figure out how to write new laws that would satisfy the court's demand for fairness and consistency. And all of that effort led to the next landmark case you need to know, Gregg v. Georgia. And this chart really shows you the before and after. The new system, which the court approved in Gregg v. Georgia back in 1976, replaced all that chaos with actual structure. Instead of uncontrolled discretion, it demanded guided discretion. Trials were split into 2 separate phases, one to decide guilt and a second one just for the sentence. And this is crucial. Juries were now given specific aggravating factors, reasons a crime might deserve death, and they were required to consider mitigating factors, which are basically any reasons for mercy. Okay, so we've got a new framework in place, but a new system brings new questions, right? The system had guardrails, sure, but how far could it go? Who exactly was now eligible for this ultimate punishment, and for what kinds of crimes? The first big line was drawn just a year after Gregg. It established this critical principle of proportionality, the idea that the punishment has to fit the crime. In this case, a man named Ehrlich Coker escaped prison and committed a truly brutal rape. But the court said that because the victim's life wasn't taken, the state couldn't take the offender's life in return. The punishment was just excessive, and that set a huge precedent for cases to come. Next up was the really tricky issue of accomplices. What about the guy who didn't pull the trigger? Earl Enmund was the getaway driver in a robbery that went wrong and turned into a double murder. He wasn't even at the scene of the killing, and there was no proof he wanted anyone to die. The court said his death sentence was unconstitutional because the focus has to be on his personal level of guilt, not just what his partners did. But just 5 years later, the court tweaked that standard. You had the Tisson brothers, who helped their father, a convicted killer, escape from prison. They gave him guns, they took part in a kidnapping, and they stood by while their father murdered an entire family. Here, the court said that even though the brothers didn't fire the shots, their major participation and their reckless indifference to human life made them just as guilty and eligible for the death penalty. So we have a framework, and we have rules about who's eligible. But how does a jury actually make that impossible choice between life and death in a fair way? Well, the next wave of legal challenges was all about the information and the procedures needed to get to a just sentence. And the core idea here is all about seeing the whole person. In a case called Lockett v. Ohio, the state had a law that was way too restrictive. It only let juries consider 3 specific reasons for mercy. The Supreme Court said, no, you can't do that. You can't put blinders on the jury. Chief Justice Burger's words here became the bedrock principle. A jury has to be allowed to consider anything about the defendant's life or the crime itself that might argue for a sentence less than death. But even with all these new safeguards, a really troubling pattern started to emerge. A massive analysis of Georgia murder cases, called the Baldus study,
came up with these staggering results. It showed that defendants who killed white victims were 11 times, 11, more likely to get a death sentence than those who killed black victims. This data was about to become the centerpiece of a huge constitutional challenge. And this led to one of the most controversial Supreme Court decisions in this area of law. The court's majority admitted the statistics were deeply disturbing, but they ruled it wasn't enough to prove a constitutional violation. To do that, the defendant, Warren McCleskey, would have had to prove that the jury or the lawyers in his specific case acted with racist intent. This decision created a massive legal hurdle, drawing a really sharp line between proving systemic bias and proving it in one person's trial. Okay, this brings us to our final section. And honestly, it might be the most dynamic concept in all of death penalty law. It's the idea that the Constitution's meaning isn't just frozen in the 1700s. It's this principle of evolving standards of decency. It basically means that what was considered an acceptable punishment back then might be seen as cruel and unusual today. To figure this out, the court looks at objective evidence, like how many states have passed new laws or what juries are actually doing, to see if our society's standards have changed. And this timeline for juvenile executions is the perfect example of this principle in action. In 1989, the court said there was no national agreement against executing 16 and 17-year-olds. But just 16 years later, in Roper v. Simmons, it looked at the very same question and came to the exact opposite conclusion. Why? Because by 2005, enough states had banned the practice that the court could say our society's standards had evolved, making it unconstitutional. We see a very similar evolution when it comes to intellectual disability. In the 1989 Tenry case, the court said, you know what? There isn't a national consensus to ban these executions, yet. But, and this is a direct callback to that Lockett decision, it insisted that a defendant's intellectual disability must be considered by the jury as a very powerful reason for mercy. This ruling really paved the way for a complete ban 13 years later, as those societal standards kept on shifting. So when you step back and look at the last half century, the Supreme Court has completely transformed the death penalty. It went from a system that was as random and arbitrary as a lightning strike to one that is highly regulated, procedural, and full of rules. And yet, as we've seen, it's a system that's in constant motion, always being questioned, challenged, and redefined. Which leaves us with one big, unavoidable question. This entire legal structure is built on the idea that our understanding of justice and decency is supposed to evolve. So with all the continuing debates over things like execution methods, mental illness, and fundamental fairness, what will those evolving standards demand of us next?